well, let me introduce our panelists, and I'm going to do so alphabetically, starting with Professor Judd Campbell, who's an associate professor of law here at the University of Richmond, where he focuses on constitutional law and history. Next, we have Professor Hank Chambers. He's a professor of law and the Austin E. Owen Research Scholar here at the University of Richmond. He specializes in election law, constitutional law, criminal law, and employment discrimination. Professor Rebecca Green is a professor of the practice of law and co-director of the election law program at William & Mary Law School. And last but definitely not least, we have Professor Ernest McGowen, who is an associate professor in the political science department here at the University of Richmond, where he specializes in political behavior, voting, and political campaigns. All right, so I'm going to start by asking each of the panelists a question to get us going. And I'm going to start with Professor Chambers. Wondering if you can give us an update on the pending lawsuits. If you can tell us what are the different types of allegations involved, and do any of the lawsuits involve enough votes to actually change the results in a state?
That is a fair set of questions. I heard there was only going to be one, but that's all right. That's all right. Let me roll them together and give you all this. Let me give you kind of a chronology of voting, which will give you a sense of where the challenges are. So we have pre-election rules, right? Things that we've heard about in terms of, say, Pennsylvania, where the question is, you've got a mail-in ballot. When does it need to get in? Does it need to get in by election day? Does it need to get in? Does it merely need to be postmarked by election day? What have you? Different states do different things. So you've got some challenges to some pre-election rules. Once you get to election day itself, the arguments have to be based on essentially fraud at the polls, right? If the notion is that I'm going to challenge votes from election day, then a lot of what goes on is I'm going to challenge fraud at the polls, issues along those lines. After election day, then folks start counting the ballot, counting the vote. You count the vote the day of, you count the vote into the night, sometimes into the next day, sometimes a couple days later, and there can be challenges based on how the counting is done. So at that point, you may have some challenges to ballots. Then after that, the question is, what do you do with the canvass or the certification? That is when you start bringing in the vote totals, the unofficial vote totals from counties, and you bring them into one place, and you try to get the state to certify the vote to say who won. There may be some challenges there. The reason why I've given you these different areas is because the Trump campaign or the Republican Party, in some cases Democratic Party, have challenged issues at various levels. However, getting to your big question, are there any pieces of litigation that would seem to change any outcomes in the states? Not right now, right? That is, most of the litigation or the claims are about sort of individual pieces of fraud. So that's really not going to be enough to change numbers. Even a recount, generally speaking, doesn't change more than a couple hundred votes. And in all the states that we're looking at, the differences are in the thousands. So for right now, until we get some additional litigation or some litigation that blows up, we're really not looking at a whole lot of litigation that's going to flip any states. What we do have, though, is some litigation that might very well stop the certifications. The Trump campaign has suggested that some of the certifications should be stopped. That is, states should not be able to finally say who won their election. And if those were victorious, then you could run into a different set of questions that I'm sure Professor Green and Professor Campbell are going to deal with. But for the basic concept, yeah, we really don't have litigation right now that's going to flip any states.
All right, thank you. So Professor McGowen, I am really excited to have a political scientist on the panel. And I'm wondering what you can tell us about voter behavior in this last election. Were there any trends that we saw that surprised you? And were there any new trends that didn't surprise you?
Yeah, there were definitely zero trends because this election was like none other with coronavirus and basically with the excise turnout. Like we had the highest votes ever for a Democrat and we had the highest votes ever for a Republican. And so I think that really shows kind of not only the enthusiasm, but there is this idea that the bigger the difference between the candidates, the more the benefit differential that you'll get from electing one over the other, and the higher the cost that you'll overcome. And so this election was one in which the costs were higher than they have ever been. And so if the candidates were exactly the same, there's no reason to stand in line for 10 hours. And so because we are in such a position where the differential between the candidates was so large, and frankly, the money was so large in that they were able to run mobilization drives all the way from July and places like that. Then I think that that was one of the reasons why we saw that particular behavior. We also saw a really strong contrast in not only the personalities of the candidates, but how the personalities affected their campaigning and how the personalities also affected how people viewed their response to the coronavirus. And so the differences were very stark in this situation. And so I believe that that is one of the reasons why we saw so much political behavior more than we had seen in past elections, even in open elections. We have to remember this was an incumbent election generally, but because of the coronavirus, it was almost like two new candidates because we weren't sure how each one would handle whatever curves come around with corona.
Thank you. So since this is a discussion at the law school, I want to turn to the law itself so that as we get into the discussions about the various legal challenges, we have that foundation. So I'd love, Professor Campbell, if you can give us an overview of what the U.S. Constitution has to say about voting rights.
Sure, thanks. So there are sort of three buckets I think we can organize constitutional principles into. One is a vertical separation of powers between the federal and state governments. Another is horizontal separation of powers between judges, legislators, and executive officials. And the last is individual rights. And so one of the things that's kind of interesting about US elections for federal office is that they're actually run by states. And so for the most part, Article 1 and Article 2 say that states are in charge of running elections for Congress and elections for the president. And that means that you have a lot of state law that's at issue, and then almost entirely it's state executive action that's actually implementing the elections, counting the ballots, and so on. In terms of the horizontal separation of powers principles, normally the US Constitution doesn't limit what states can do within their own structure of government. So the US Constitution, for instance, does not require certain non-delegation principles at the state level. It doesn't require states to have veto provisions or anything like that. But with respect to elections, it's actually potentially a little bit different. And this is one of the friction points in constitutional law right now. The Article 1 and Article 2 provisions that assign powers to states to run federal elections say that it's up to the state legislatures to set election rules. And one way of interpreting that, as endorsed by 3 of the justices in the Bush versus Gore decision, as endorsed by 4 justices in the Arizona Redistricting Commission case from about 5 years ago, and then also endorsed just within the last couple of weeks by 4 of the Supreme Court justices, notably not including Justice Barrett. The position here is legislature means legislature. It doesn't mean the state constitutional apparatus. And that means that if a state constitutional provision, as interpreted by state court judges, somehow takes priority over what the state legislature has set for the rules for federal elections, then we have an Article 1 or an Article 2 problem under the federal Constitution. And that's a very controversial reading, but it's one that's going to be incredibly important in the years to come, because in 2005, it was only a 5-4 vote. Actually, Chief Justice Roberts was in the dissent in that case. And now we have an additional justice, and it'll be interesting to see what happens with that. For now, as Hank said, likely not to matter for this election, but it's going to be profoundly important for the years to come. The last constitutional bucket is rights. And interestingly enough, there is no federal right to vote that's specified. There are only various non-discrimination rules. But there is a implicit right to vote that the court has recognized through the 14th Amendment Equal Protection Clause. And so a lot of the basis for the challenges that have been made in the recent elections, this is true in normal times, not just in times of COVID, is that in order to make voting available, it has to be consistent with various individual interests in having your vote heard, and the state's effort to suppress the vote without a sufficient justification violates not just potentially state constitutional provisions, but the Equal Protection Clause. And so the various challenges that we've seen in this election trying to make voting more accessible, some of those have been upheld, some of them have been struck down, are generally litigated either under the state or federal equal protection principles that protect the right to vote.
Thank you. So Professor Green, I want to turn to you and thank you so much for joining us tonight. So I am not an election law scholar, but my sense is that the Constitution is just the tip of the iceberg when it comes to election law. And so I'm wondering if you can tell us some of the main other sources of law, the main other laws that we should know about as we evaluate this election season. And then Hank called me earlier on asking a two-part question, so I'm going to ask a two-part question here, which is going back to this dispute about mail-in ballots and when they can be received. And I'm wondering if you might be able to tell us your sense of that litigation.
Sure. Yeah. So I think actually Professor Campbell just provided a really lucid and helpful background to this whole situation, which I think starts with the idea that states really do run elections in this country. And that means that we have 50 different sets of rules for how elections should be run. And some of the rules, have been under a huge amount of stress this year, given that states ran an election in a pandemic, which meant, that there was this like crush of reexamining what those rules meant in terms of ensuring that voters could access the polls successfully. And that really ranged. So in a lot of states, absentee voting was high. In 5 states, those states conduct their elections by mail entirely. In some states, like unfortunately Pennsylvania, that had a very low rate of absentee voting, which obviously has increased dramatically this year. So there's just a whole range of impacts on the states that states experienced as they were trying to cope with voting in a pandemic. And we had some alarming, first runs at this during the primary season, where I'm sure all of you, or many of you for sure, saw the lines in Wisconsin where people were forced because of disagreements over who had authority to make accommodations during a pandemic. You had people literally choosing between their health and their right to vote in the very scary early days of the pandemic. So over the course of the summer, we saw just a huge amount of litigation, an unprecedented amount of litigation, where mostly voting rights groups were challenging whether or not states were accommodating voters sufficiently in a pandemic. And the courts really had to kind of, for the first time in these cases, kind of address these questions using some of the constitutional tests that Professor Campbell described. So it had a profound effect on how we voted this year. These decisions. We had last minute questions, for example, the curbside voting issue in Texas. We had some questions that were raised very early on. For example, the question about whether you had to have a witness sign your ballot if doing so was onerous for people who lived alone. And so what I think is extraordinary about that the litigation that we witnessed, over 300 cases, is how well our court system coped. I mean, you may quibble with the decisions that were made, and certainly, it was quite extraordinary how often the federal judiciary, denied accommodations for voters during the pandemic. But either way, those decisions were respected, and we sort of moved on with those rulings in place. And so, to me, it really, the judiciary was tested, and I think it passed in terms of setting rules and providing clarity in a very difficult situation. So. So those are sort of that's sort of what we've all seen unfold in the last several months, and I think like the election itself, it all unfolded surprisingly well given the circumstances that the judiciary was operating under. One of the trickiest questions, just getting to the second part of your question, had to do with absentee ballot deadlines. And the question was essentially, as it came up in Pennsylvania and also in Wisconsin, was who has the authority to extend absentee ballot deadline? And what's critical to understand about this question is that it's not who has the authority to let people vote after Election Day, because no one was proposing that anyone would be allowed to vote after Election Day, which would be a horrible idea, right? Because you would know, who was ahead and all that. The question was, could you extend the deadline by which ballots that were postmarked on Election Day or by Election Day, when those could be received? In Pennsylvania, the Pennsylvania Supreme Court extended that deadline until the Friday after the election. And the allegation was because of Article 2's delegation of the US Constitution's delegation to state legislatures the power to set the time, place, and manner of elections. The idea was that only the legislature could make such an extension, and that would put into question the number of ballots that were received after Election Day but postmarked by Election Day. And so that bucket of ballots was, or is, I guess, sort of at the center of the storm. As I understand it, I think that it's around 10,000 ballots, so it's not outcome determinative, and it's really going to be more of a if the question does make it to the court, if the court decides, I don't think it will have any impact on the outcome, particularly since the US Supreme Court was asked to stay the Pennsylvania Supreme Court's decision. It elected not to, and you can make a very strong argument that the voters relied on that extended deadline when they cast their ballot. So it would be, it's one question, whether on the merits that the Supreme Court will decide in favor of the state legislature. But I think it's a totally separate question about whether they would invalidate any ballots as a consequence of the reliance that the voters had. So it's a really interesting case, as Professor Campbell said. And I think that there are a lot of eyes on the court, because it would be a ground shift if, in fact, a state Supreme Court couldn't interpret rights in its constitution to accommodate voters in a pandemic, and obviously in other situations as well.
Thank you so much.
Mm-hmm.
All right, so I want to take this opportunity now to open it up for questions. And so I'm going to put into the chat something that I said earlier, which is that we have 3 ways for you to ask questions. First, you can go ahead and raise your blue participant hand. Second, you can go ahead and type your question into the chat. And finally, you can go to the form that I linked there. And I know some of you submitted questions earlier, and so I've been looking at those and I have those ready. That form's anonymous. And what I'm going to do is try to rotate between those 3 methods so that we can get in all of them.
Can I make one point on Pennsylvania for just
go for it?
Yeah,
absolutely.
Yeah, because I want to bridge something that Professor Green and Professor McGowen said. For those folks who watched the Pennsylvania returns, I think it was probably Thursday or Friday, President Trump was up by a bunch of votes. Then the absentee early votes came in. And on a number of occasions, they were 90% to 10% in Joe Biden's direction. One of the reasons why that occurred is the concept that some folks were told, get your mail-in ballots, and others were essentially told, go to the polls. That distinction, that huge distinction, meant that in Pennsylvania, the lion's share of early votes and the lion's share of mail-in ballots came from Democrats in a lot of cities. And what it suggests is that we really have a bifurcated group of electors right now. and that I think sort of feeds into what Professor McGowan was saying in terms of this election was very strange, was very polarizing, and was just sort of crazy in some ways. But the craziness is based on the rules that were in place, the laws that were in place for voting that moved us into two very different directions in Pennsylvania if you were Democrat or Republican. So I just wanted to mention that piece of the puzzle.
And can I make another point?
Sure can.
So I think it's important that we not look at this in a vacuum. I know y'all are all lawyers, but like the stuff that was happening when the first rules were passed actually got litigated. The things that are happening now were things that have already been litigated, and these are just political maneuvers, okay? And so it's very different from actually contesting what the rules of the game are going to be than going back and saying, okay, we want to change what we already talked about. And so you need to start thinking about these pleas by Trump and these allegations by Trump more as political maneuvers to the base as a signal of still fighting for the election, not necessarily something that they believe is actually going to stand up on its political merit, because we've seen plenty of lawyers say that they're not even going to take the cases, and plenty of lawyers that are saying that the cases are not going to go through. And so if we view what he's doing more as trying to send a signal to his supporters as opposed to actually believing in the merits of the cases, you may understand a little bit more why it's so scattershot. Count these votes, don't count these votes. This day, this deadline is too long, this deadline is too short, and things like that.
So it's not all about the law, Professor McGowan, is that? Yeah. So I'm going to bring in a question that came in through the form, which circles back actually to something Professor Chambers said at the outset, which talks about what happens if a state does not certify its results. In other words, is there a date by which a state must certify its results? If it does not certify the results, then what? And I'll open that up to any of our panelists.
Hank, do you want that, or you want me to?
You go for it. You go for it.
Well, I mean, there's a date specified by federal law as to when the certification has to take place. And if there isn't an electoral slate that's set by that date, I think it's a week or two into December, then the state doesn't enjoy the benefit of the safe harbor provisions of federal law that require Congress to consider the electors that are selected by that state as being properly elected electors. And at that point, it just becomes Congress's responsibility to recognize the correct slate of electors. I think there's very little likelihood that that's going to be an issue this year.
And sorry, just to follow up, when you say then it turns to Congress to recognize the correct electors, how? Is it both houses of Congress? Like, how does that happen?
Yeah, so the Electoral College is not actually it's not actually a college, and it is not very low tuition rates, and it does not actually meet in any one place. So that you have these different state conventions. The state conventions are then responsible for certifying their choice as to who the president and vice president, as chosen by that state, will then go to Congress, and at that point, Congress has to read off the various state election results and then tabulate what the outcome is. If there's a majority and it's recognized pursuant to federal law that the various electoral votes cast are valid, then there's nothing left to do. If there's not a majority, then you have to go into the constitutionally specified process for determining who the president and vice president are. And that involves selecting by state delegation the president and vice president. And that process can become very convoluted. Thankfully, we haven't had that process since the 19th century.
Thank you. So another question from the form, which is, how positive are we that the votes at issue here in these various lawsuits don't have the ability to affect the result in any state. In other words, are we 100% confident on that? Are we 75% confident on that? How worried do we need to be, it says this person, that the result might flip?
Go for it, Rebecca. I saw you.
Oh yeah, I never know.
Yeah.
Well, I'll just take a quick stab, which I'm sure you can add to. So there's two parts of this. The first is, do the number of contested ballots at issue, is that greater than the margin between the two candidates? And in no suit that I'm aware of are the number of contested ballots anywhere approaching the margin between either the candidates in any state. So that's sort of, I guess, one question. And then the second question is, are there meritorious arguments? Are there arguments that are on their strength, have an opportunity to somehow, affect a huge number of ballots? And on that question, again, we haven't seen any arguments that I think rise to the level. That doesn't mean that there won't be, cases filed, in the future, in the next several days, or even in the next couple of weeks. But so far, on neither front have we seen anything approaching, a result that would change the outcome of the election as it stands.
That's right. I'd say probably we're over 99%. Part of the reason why is because election officials are incredibly fastidious in terms of getting it right. I mean, it's not like they just walk up and say, yeah, I think there are a couple hundred votes here. No, they are hardcore people who count every single vote. So by the time we're down to this time, they've done a lot of counting. Now, there may be some votes that change, but rarely do many votes change. So I'm with Rebecca. It is almost inconceivable that there will be a change just based on recounting votes and based on a small number of allegations of fraud.
And I guess I'll just say, it may not be that the number of votes is actually going to change the winner or the loser, but there are automatic recount provisions. And so it may kind of narrow, it won't, but possibly it could narrow it to where there's an automatic recount, even if the other person doesn't actually become the winner or the loser.
And actually, Professor McGowan, I have a question that came in for the chat for you, which is to follow up on your point about sort of the end game here. If the litigation does not involve enough ballots to change the result, wondering what you as a political scientist see as President Trump's end game, especially if ultimately, if it doesn't change anything, does it actually fire up his base in the long run?
Well, yes, I think you have to understand that Trump has run on a campaign that the establishment is against him and against them. And so when you start pointing towards nameless bureaucrats and different officials and things like that, it plays into this idea that they just want him to lose and they're going to cheat for him to lose. Whether or not it's actually true and whether or not it actually stands up, it still plays into a perception about what the country feels about and who the country likes and who they don't like. And that has fueled a lot of his turnout. And so I know we're looking way down the line, but when 2024 comes, if that narrative is still playing out, then it's going to help him if he chooses to run again.
The other thing I would add here is just this is Donald Trump, the person's MO in life. He gets criticized and he sues for libel. The point of those suits is not to win. The point of those suits is to posture and to intimidate. And so we see this sort of excessive and very quick resort to litigation as just a general strategy in his entire life.
And so, Professor Campbell, there's actually a question again, and you're welcome to private chat me. I'm getting a lot of questions in through private chat, and I see them, and I'm going to get to them as fast as I can. And this one, Professor Campbell, goes to the constitutional law piece. If the U.S. Constitution says fairly little about how elections can be held, what exactly would the Supreme Court be able to do? And more specifically, what part of the Constitution would they have to use to justify any decision that they make?
So it really depends on what the plaintiffs are asking for and who's winning at that point, you're in a much better position if you're up in the count, because then you can use litigation as a way of slowing down the count and kind of running out the clock. And President Bush's team did that very effectively in Florida. They were able to do enough obfuscation through various legal and extra legal means to basically get to the point where the Supreme Court said, there is a equal protection right at issue that calls for a statewide recount, and there's not enough time. And so that was an effective strategy at that point. But it was only effective because Bush was up. And so the additional votes, there wasn't enough time to go through the additional vote recount process. That's not true here. So the opportunities for the Supreme Court to intervene in somewhat dubious ways are just not, they're not there this time. So I mean, we can just sort of wildly speculate as to off the wall theories that the Supreme Court might come up with, but I don't think they're going to do that. And I think one of the reasons why they're not going to do that is because President Trump was promising fraud in this upcoming election 2 or 3 years ago. And so they recognize this for exactly what Professor McGowen is saying it stands for, which is just a political posturing. And the court has no interest in delegitimizing itself to try to interfere in an election like this.
And we'll also say, just because some of your students probably weren't even born, so Catherine Harris, the Secretary of State, actually said the recount should stop. And so the Supreme Court then said, okay, we'll agree with the duly elected official that said the recount should stop. And then that's when Bush became the winner.
Seems like a long time ago, doesn't it? And yet here we are again. Another question's come in about the GSA, wondering if there's a point where GSA Administrator Emily Murphy or other administrative agencies must accept and begin the transition process. And if they don't, is there a legal recourse for the Biden team?
I have not looked deeply into the Presidential Transition Act. My understanding is that the head of the GSA has to make an ascertainment that a candidate has won. I suspect that when we start to get full state certifications and it becomes eminently clear that one of the candidates has more than 270 votes based on the certifications, at that point, I presume that the GSA head will say, okay, at least by that time, we'll say, fine, we're going to go ahead and move forward. I don't know whether there is a mandamus possibility or anything along those lines that would allow a court to require the transition to occur. I have not quite seen that yet. I hope we don't get anywhere near that, but these are strange times.
Yeah, and I think we don't actually know for sure what the outcome of such litigation would be. I mean, I think that would be a quintessential political question that the court would properly not intervene to try to mandate the release of transition funds. But that's just my guess. I really don't know, and we haven't seen it tested.
And then to follow up on that, I had a question here about what types of actions President Trump can take before Joe Biden is inaugurated on January 20th. Are there executive orders we might expect to see, pardons, judicial appointments, executive branch appointments? What is the next couple of months going to look like? That may be a big question, right? If you don't have a crystal ball, but just what would you speculate that we might expect from now until
I'll
then?
just say, as far as the executive orders go, like Joe Biden on the 21st could come in and just write, do the opposite on the top of every single executive order and put it in, and then everything would change. And so the whole executive order part isn't really, now the pardons, as we saw with Bill Clinton, right, they're gonna stick. The whole pardon himself thing, I don't know about that. The pardons will stick, but the executive orders, every single time, an executive order is nothing because the legislature can always just make a law that says whatever this executive order is, we don't want that or we do want that. And so all of those are going to go away as soon as Biden gets in office.
So I don't know if this directly answers that question, but I think one of the things that's emerged that I think is really pivotal is the issue about the 9/11 report, talking about how Bush versus Gore pushed the the transition back for Bush to come on board. And the 9/11 report, and sort of looking at the causes of that disaster, cited the transition being shortened as one of the problems. And I think that's getting a lot of play, and people are quite concerned. That here we might be essentially making ourselves more vulnerable to, an attack or some bad event in terms of national security unfolding. And I think those kinds of pressures are going to start to really sort of set the timetable on how this transition can unfold. I think that's going to be a really strong argument.
Yeah, and let me just add one last piece, which is we say that we have one president at a time, and right now that president is President Trump. So to be perfectly honest, until January 20 noon, he's the president. So stuff can happen. And however much power he has under Article 2, that's as much power as he has until January 20 at noon.
Speaking of that power, a question that I just received wants to follow up on the pardon power. Does the president have the power to pardon himself?
So the pardon power is one that's not textually limited. The current court is pretty staunchly textualist, which indicates to me that they would likely not see any judicially enforceable limit. I think it's an interesting question. It's certainly a corrupt use of the power, and you can make a strong norm-based argument, a sort of spirit of the Constitution argument, that it shouldn't be used corruptly. But in terms of judicially enforceable limits, I think the answer's probably not under at least this court.
I suspect that's right. I'll just note that in the past, I used to use self-pardoning as almost a punchline when talking to folks about constitutional law. It's not a punchline anymore. What I will say is, from a political perspective, things get kind of interesting because you can pardon yourself for federal crimes, but not for state crimes. So it does raise the issue whether a president who, assuming it's allowed, whether a president who pardons himself for federal crimes likely raises the ire of states that wouldn't normally prosecute him, but that decide, you're trying to be cute, we're going to go after you. It would be an interesting double-edged sword.
And what Hank is referring to here is state crimes committed as a citizen, not as president. So there would not be any state criminal liability for anything that President Trump has done in office, but there would be for anything that he did as a private citizen before becoming president, or for any private activity while he was president.
Going back to the election litigation, I've gotten a few questions from panel or from audience members wondering if these lawsuits, many of them appear to be frivolous, why aren't we seeing more 12b6 motions? Why aren't we seeing more requests for Rule 11 sanctions? And I'll just say that is a question that a civil procedure professor loves.
I mean, I'm surprised too. And, I'm on a listserv with a bunch of election law professors, and that was one of the early questions is, where are the sanctions and what's going on? And, we've seen some reporting in the press about, judges coming down hard on campaign attorneys who are bringing, evidence that is less than, solid, let's just say. But yeah, I have to say, I'm surprised too. And I wonder whether, as this unfolds, if it continues to be this week, whether members of the judiciary will start to get fed up. But I'm sort of surprised that we haven't seen that so far, at least given the reporting and the if you read the complaints, it's they're long, but there's not much there happening.
So I'm wondering if we might shift towards the future and perhaps the legacy of this election. And obviously, a lot has changed in our day-to-day lives as a result of the pandemic. And I'm wondering what you think the lasting impacts of this election will be. And maybe we'll start with talking about any legal changes that we might expect to see coming out of this election, and then we can talk about more of the societal effects around elections more generally. But starting with the law, do you expect to see long-term changes there?
You know, I actually do, and possibly in a positive direction. That is, I think folks are starting to realize we can vote in a bunch of different ways. When folks say, well, we ought to vote on Tuesday, and you ought to go to the polls on Tuesday, and that's when you ought to vote, I think a lot of folks are saying, yeah, no. We really ought to be able to vote in a whole bunch of different ways, and it may well be that states pass laws that allow those kinds of things. Virginia was moving in that direction. Virginia actually changed a number of laws, for example, going to no excuse absentee voting, which essentially allows early in-person voting in a way that moves a lot of the election ahead of the election day. I could see a lot of those things occurring. We may start rethinking how we deal with signature requirements on absentee ballots. So I suspect that a loosening that allows more people to vote might be in the offing. Of course, I might just be Pollyanna on that one.
One of the things, so I don't know the answer to this, but one of the things I'll be looking for is to see how the Republicans' more open embrace of voter suppression affects the Supreme Court's decision making. I think the Supreme Court was comfortable with soft efforts at voter suppression, like ID check laws. There's a famous case in 2008 called Crawford out of Indiana, where Justice Stevens writes the majority opinion upholding the voter ID check as saying, look, it's not that hard to get a voter, it's not that hard to get an ID. If you can't get an ID for some reason, you can bring an as-applied challenge. And the court was pretty much comfortable with most forms of limits on voting that could be justified by sort of hypothetical reasoning about what may or may not cause either election impropriety or the appearance of election impropriety. The Republican Party, I mean, I'm overgeneralizing here. The significant parts of the Republican Party now are just being very open about an interest in having fewer voters and trying to make voting harder. And that will have reverberations in states that are Republican controlled, but I think it might also have reverberations for judicial tolerance. And so it'll be very interesting to see how some of the Supreme Court justices who will try to develop their own legitimacy deal with that. And I don't know the answer to that. I'm not suggesting that there's all of a sudden going to be a move away from Supreme Court tolerance of those sorts of laws. I would be very surprised by that, but I think you might see the Supreme Court trying to steer a middle path, at least in some of these cases.
And I'll just say the court has definitely, the judiciary has definitely become politicized. And I don't need to tell your students that Article 3 is the vaguest, is the shortest, says absolutely nothing, but it does say that the politicians are the ones that decide it. And so we may see, and so a lot of what we know of as the courts, the number of circuits, the number of Supreme Court justices, things like that, are just kind of norms of behavior that we have adhered to, but not that the rules necessarily constrain. And so we may see that some things actually change as far as the structure of the judiciary is as we've known it.
Yeah, and I think just building off of that as well, I think one thing that we definitely saw, you know, in this huge spate of litigation over the summer, spring and summer, was that there was this huge deference to state legislatures. So like Professor Campbell was saying, you know, if a state legislature wants to do it in the election realm, it seems like the court as it's currently constituted is pretty much ready to let them go with it on very little, you know, without going through the typical sort of burden evaluation that courts have done since Crawford. So that's one thing. And the other thing I would say, you know, potentially on a more positive note, is that if there's anything that we've learned, it's that the state emergency laws as they relate to running elections are in really bad shape in this country. And there was this huge panic to figure out who had authority to do what, and what could be done in terms of altering the rules of elections to accommodate an emergency. We also sort of saw that it might not just be one emergency that we're dealing with. We may have a hurricane within a pandemic, and whoever knows what else. So, so I think one positive, takeaway potentially for state legislatures from the last 6 months will be to take a look at the state election emergency laws and the emergency laws in general, and try to kind of shore things up where there were gaps.
Thank you. Wondering about the societal impact of this particular election. If we come out of this election with a lot of people believing, whatever the courts hold, that voting irregularity and outright fraud contributed to Joe Biden's win, what can the federal and state governments do to increase public trust in the fairness of elections?
People still think 2000 was stolen. So, there's not much that you're going to do when it comes to convincing people who are aggrieved and lost that they didn't lose, who actually think that their candidate was right and their policies were right, to actually think that other people don't believe in what they actually want to happen.
I totally agree with that. There's a long-standing tradition in this country of, if you lose an election, you think something, you think it was stolen. But I will say, and I'm sort of beating a dead horse because this is what I always say, but I think the only way forward is transparency. And, you have to show people, how people vote. You have to show people how votes are counted. You have to open up the process. And I think that's really the only way to build trust. But I think we're in a really dangerous situation, given not only the polarization, but just the huge numbers of people who are not confident in the outcome of this, the millions and millions of people who aren't confident in the outcome of this election, particularly. So I do worry about that. And I really think it's about, my dog feels strongly the same. My dog is underscoring my point, but it really seems to come down to transparency for me.
That's right. And those folks who didn't happen to see Rebecca's op-ed in the Richmond Times-Dispatch last week on election transparency, feel free to take a look after the session is over.
You're muted, Jessica.
It wouldn't be a good Zoom meeting without a tech failure, so. All right, so should I read this out? Okay, Jessica writes, suppose somebody tweets that the polls are open until 9 p.m. despite knowing that they close at 8 p.m. Can the state, if it has an applicable law, prosecute that person? If so, how far does the state police power go in combating misinformation? Yeah, this would be something you can prosecute. This is an effort to manipulate and interfere with proper execution of elections. It is an instance of speech that would be deemed unprotected by the First Amendment. The First Amendment would not provide you protection against false speech that is designed with some motive to undermine lawful elections. And so states actually all have laws that closely regulate the sorts of things that people are allowed to say about the election process. The things that are much, much harder to regulate are slightly more meta points about the election, sort of alleging in very general terms that the election was fraudulent. Those sorts of things have undermining effects on public legitimacy, is the way that Rebecca was just mentioning. But those sorts of generalized comments are not protected. Excuse me, those sorts of generalized comments are not subject to state regulation under the First Amendment. And so it has to be sort of specific efforts to mislead voters. Okay, I'll read this one off, but won't answer. Where does the polling industry go from here? It appears that the polling industry is facing similar criticisms as 2016.
All right. So in 2016, the polls got it right. They said Hillary Clinton was going to get more votes, and she got more votes. In 2016, if you look at the state polls, there were only like 3 state polls per battleground state in Wisconsin, Michigan, and Pennsylvania. And so there's no reason why you would put any credence in that. In 2020, the poll said that Joe Biden is going to get more votes. He's probably going to get more votes. You have to remember that when there's a margin of error, both candidates have a margin of error. So if they put Joe Biden at 10 points, if you will, take 3 away from Joe Biden and add 3 to Donald Trump, and statistically, they're saying that the likelihood is that it could be 4 points in the spread, which is probably what you're going to see in a lot of these Wisconsin type states and things like that. And so you have to kind of understand the nuances of polling. The media does us a disservice when they actually talk about it. But if you actually understand the concepts of statistical inference and things like that, the polls were never designed to get it right. The polls are incapable of getting it right. And they tell you that they're not getting it right through the margin of error. The other thing that you have to understand is that the instrument is only as good as the people that it talks to. And if certain numbers of people have some kind of political motivation to not talk to the pollster, and the pollster wants to get a balance of Democrats and Republicans, but the Republicans that they are getting are not the super Trump Republicans, then they're always going to downrate the Trump support and uprate the Biden support. So we have to be really careful about this narrative that the polls got it wrong without really understanding that it's a flawed instrument from the beginning, and any pollster or any quantitative political scientist will tell you that.
All right. Well, let me note one more thing about numbers. You can go ahead and throw another question in the Zoom chat, but I want to just mention one more thing about numbers. One of the big things that has not been covered about this election is that this election was also the last one before redistricting occurs. The 2020 census, of course, is this year, or was this year, depending on how long the courts say it's going to last. And as a consequence, every state needs to redistrict. When that occurs, we'll see what happens with the state legislatures. We'll see what happens when it comes to congressional delegations. And particularly because now this is the first redistricting after census where it is clear that partisan gerrymandering is allowed. The Supreme Court decided last year, just said, look, we're not getting in the business of this. It's a political question. So if you thought the 2020 election was interesting, just wait till you get to redistricting in 2021. It could be a bloodbath.
All right, I'll read out the next question here. What role do you think social media played in this election? What would you like to see the government change to adapt to a world where everyone is connected and information spreads so fast?
I think a bit of historical perspective is due here. So the first newspapers were like actually run by parties. Like this norm of objective journalism was not a thing for most of our country's time. And so while we may look at social media, which are for-profit businesses to be sure, and think about their effect on democracy, I think we kind of have to understand that it's never been a game of fairness. It's always just been a game of winning.
I will say, though, that the Supreme Court often relies in First Amendment cases on this idea of more speech, or the marketplace of ideas kind of swooping in to address things like false campaign speech and other problems that we have in the speech arena, particularly with political speech. And I have to say, it does seem like with our current fire hose of information, it does seem like that concept that more speech is a cure to false speech, or problems in the marketplace of ideas is it's just it seems like the whole premise has shifted, and it'll be interesting to see whether that will have any impact on the court, although I don't think it will, given the court's current composition.
But we regulate things like the Food and Drug Administration, right? You can't sell rancid meat, and the market's supposed to take care of that. And so, yes, if it gets out of hand, I definitely think that the Supreme Court could step in and say, well, wait a second, we need to actually tamp this down.
Yeah, I think the whole issue about lies in political campaigns, and so far the court giving it sort of a bye, seems like it could conceivably change. But again, I don't know with the composition of the court whether that's possible.
Next up, we've got there's been a lot of infighting reported among Democrats, with moderates clashing with folks who are on the further left side of the political spectrum. How do you see this split playing out over the next couple of years?
Well, I guess it all depends on, number one, the loudest doesn't mean that you're necessarily the most. And so, and the means by which you protest doesn't necessarily mean you make up the most of the body. And so I definitely think that there is a schism between the quote unquote moderates and the progressives. It has started in 2016. And I think that it could hurt in 2022, but I think by 2024, particularly if Donald Trump runs again, that the quote unquote progressives, particularly if he stacks his cabinet with those kind of people, will come back into the fold. But you may see primary challenges, to be sure.
Yeah, watch for redistricting. And to see whether folks will end up in districts where primaries are going to be really messy. It could get quite interesting. It does seem that there's another piece of the puzzle, and I recognize the question may have been from a Virginian who was thinking about Abigail Spanberger. Just an example, in Virginia, Abigail Spanberger will never run in her district again because her district will be changed. Now, what it will look like when it's changed, who knows? But it's going to change, and it could change significantly given how it's structured. So it's going to be really interesting to see how people have to deal with running in new districts and districts that might not be as hospitable or maybe more hospitable to them moving forward.
All right, great. Well, we're at time, and really appreciate everybody coming. Thanks to my co-panelists and to Jessica for her great work live 50 minutes and by keyboard the last 10. And thank you all for coming. It was really a good conversation. I was glad to be a part of it, and privileged to join these other fine folks as well.
Thanks so much. Y'all did a fantastic job. I appreciate it.
Thanks, guys.
And thank you for our sister down from up from William and Mary.
Yeah, thanks for having me.
Yeah, thank you for having me as well.
Take care, y'all.